The pretrial reviews in the matter of TCD 009-2020 and is being held by way of video conference before Justice Lord Angus Glennie. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Alaida Rose Advocates and Legal Consultants. Lead counsel is Martin Kostel. The defendant is represented by Charles Russell Speechleys, LLP. Lead counsel is Thanos Carvelis.
Thank you very much. Mr. Kostel, it's you to begin, I think.
Yes, we're hoping that this can be a quick hearing, my lord. There would have been...
I've read the two checklists and the protocol, and there doesn't seem to be anything significant between you.
No,
I don't think.
No. There shouldn't be anything of significance between us at all. Can I just say one thing about the? I'm grateful for the indication, but can I say one thing about the timetable, which I've spoken with Mr. Carvelis beforehand?
Yes.
We are hopeful to, in fact, to finish up the evidence, certainly in terms of the trial by day 3. We are, let me say, optimistic, and I hope we're not overly optimistic, but that's the intention. But you would have seen at, I think it's page D4 of the bundle, that the present timetable caters for 5 days, and we're of the view that at its worst, it should really only take us to lunchtime on day 5. But in reality, we're hopeful that it concludes in day 3. And obviously, if it concludes at day 4, then so be it. But on that point, we are both of the shared opinion that after the conclusion of the evidence, that the parties be permitted to provide written closing submissions instead of oral submissions, for the simple reason that the evidence of fact is rather contentious. So that there'll be quite a lot that needs to be dealt with in that sense, and the experts will have a lot of technical evidence which we will need to, I suggest, with reflection, perhaps make our submissions. And indeed, there will be matters of UAE law which both parties will opine on. I'll just wait for.
Of course.
Yes. So apologies about that. It was,
you were
unexpected.
A cup of coffee.
Exactly. It was. If I had known, then I would have stopped sooner and at least given you notice. Although I would have probably asked for one myself. But anyway, I'll move on. So the point is, my learned friend, I think, agrees that the parties be permitted to provide their closing submissions by the 29th of July, which is agreed between us. One round of submissions only. In that regard.
Yes, I'm not against that, and I think it's often useful to have a gap between the end of the evidence and submissions.
Yes.
The only thing I'm concerned about is that if it's all in writing, you may be raising points on the evidence or as a matter of UAE law or something of that sort, which takes me by surprise, on which I would need some help.
Yes.
So I think we'd have to build into that if, having seen the written submissions, I thought it was necessary to have a short oral hearing, allowing you maybe half a day each or something of that sort, that I can do that.
Yes, speaking from our perspective, I have no issues with that at all.
Mr. Carvelis, are you happy with that?
Good morning. Yes, Your Honor, it's absolutely reasonable, and I will confirm what my learned friend described just now, that this is indeed what we discussed. We are hopeful that we will be able to wrap up before day 5. We will do our best to finish by day 3. We may need, if I'm honest, I think we might need day 4. But I think we can spare day 5, and there are a couple of points I would like to discuss, if I may, later on, which might help on this. As for the closing submissions, I am in agreement for submissions in writing with a footnote, though, unless, of course, Your Honor, you will be prepared to issue judgment upon conclusion of the hearing. In which case, I think we can do some short oral submissions. If not, of course, it sounds reasonable, yes, and we will be available for a follow-up hearing if questions on law arise that you would like to discuss.
So the date for written submissions was the 29th of July, is that right?
Indeed, I think this is the one.
And they're going to be a blind exchange.
Yes.
Yeah. Because I think then it's just, you needn't go into the order, but it's important if there are going to be detailed written submissions that any point of potential difficulty or controversy be focused in the cross-examination or the examination in chief, so that they don't catch me unawares when I come across them in the written submissions after the evidence, when it's too late to try and understand them.
Yes.
Understood, Your Honor. Noted, and it makes sense. On this, if I may, I think we could agree a limit to the page number of the closing submissions. I mean, I'm sure my friend and I can resist, the temptation of very long submissions in the middle of July.
What do you suggest the limit should be?
I have not discussed this with my colleague, but I think 20-25 pages should be more than enough, especially if it is to focus on what has been discussed on cross-examination. What do you think?
My lord, can I say that at this stage I'll agree, but can I put this reservation, that ominous word, can I put this reservation that depending on how the trial goes in any particular way the evidence comes out, which may need a bit more, I don't know, submissions or explanation or anything of that nature, then at the trial we can discuss it at the conclusion, or at least revisit the point then, just to see where the parties stand. Provisionally
about 20-25 pages.
Let's say 25 for now, and then, as you say, provisionally. Yeah.
Right. Is that all then on this aspect of the matter?
One matter can I just raise? Sorry, I should say it just occurs to me now, and I apologize to Mr. Kovalis. I didn't mention this to him, but I hope it doesn't take him too much of a surprise. But in terms of cost submissions, I don't know if those should be made at the same time as the closing submissions. I would imagine it should, or at least we could wait, or another approach, and I'm thinking on my feet, as it were, or sitting down, I should say. But maybe that should follow judgment, and then maybe the parties can provide submissions at that stage.
Well,
it wasn't.
So I was going to say, shouldn't that be dealt with at the end, once we know at the conclusion of the oral evidence? We will have a better idea then as to whether you want to say anything particular about costs or whether they should simply follow the event. Mm. But what were you going to say, Mr. Carvelis?
I was going to say it was one of the few matters on my list for today's call, yes, because we didn't have the chance to discuss it with my friend. Yes, I think it makes sense if we, again, it depends how the trial will go. What stage we will be at the end of the last day of the trial. I think we can decide it. Yes, then we will be prepared to make submissions then and there if necessary. Otherwise, I think it can be combined with the closing submissions. It's up to your discretion, Your Honor.
I think, unless Mr. Costello, you want to add anything, I think we should. In principle, it'd be useful to have any submissions in outline at least before we part at the end of the evidence. But if you say, well, it's actually more complicated than that, we want to put in some written submissions, then both parties can do that. But let's take that decision at the end of the evidence.
Yes, I'm content with that. Thank you.
Thank you, Your Honor.
Right. Well, what next, Mr. Costello? Is there anything as I understand it, just looking at the evidence we're going to expect.
Yes.
On your side, Mr. Koshel, there is one fact witness and 3 expert witnesses. Is that right?
No, one fact, as you said, but 2 expert witnesses. I think the confusion is the way it's been written out and on the form. It's Jimmy Lo Yu Hone. That's the full name of the technical expert, and Stephen Millington is the expert on the TCD 003 matter.
Yeah.
So two witnesses. Yeah.
And for the defendants,
2 factual witnesses, Mr. Al-Mahdi and Mr. Nair, and 3 experts, Mr. Sporl on delay, Mr. Craig on quantum, and Mrs. Levin on TCD3 in response to Mr. Millington. So 2 factual witnesses, 3 experts, and actually, if I may, Your Honor, on that, and because this is a follow-up of a discussion I had with my friend recently, I was wondering if Mr. Nair will be required to attend for cross-examination. I'm not sure if my colleague does intend to cross-examine Mr. Nair.
If I can put it this way, to assist the court, at present I do require his attendance, but I assure Mr. Karvelis, should we no longer need him, we can dispense with him, then of course we will let him know.
No problem.
If you can try and let him know as early as possible, because it obviously affects both his arrangements, but also it affects the timing of other witnesses.
Indeed, if we know if Mr. Nair will be required or not, if he's not, then we save an afternoon, which means that Mr. Law will need to be available. So yes, if we can know.
Yeah, right. One thing occurs to me: we've got experts on different topics. Particularly, we've got experts on I've forgotten what we call the issue. Claire Levine and Mr. Millington speak to the same issue. I think, is that right?
Yes.
Is it sometimes it's sensible to depart from the usual process of claimants' witnesses followed by defendants' witnesses, and to have witnesses, expert witnesses on the same topic following each other?
Which is how, if I may, Your Honor, which is how my friend and I thought that we should arrange it, if you notice, because the way it is structured is that following the opening submissions, factual witnesses, cross-examination of factual witnesses will be the next step. Nabila Kiki, Salim Ahmadi, and then
Mr. Karvelis, are you looking at some document I should have?
And yes, I thought the timetable, Your Honor, at D4 of the bundle.
Yes, I was looking at the. Hang on a sec.
Yeah, if we can share it on screen, if it would be more convenient.
I've got it here. I have it here now.
Thank you.
Which paragraph of that deals
D4.
with the?
If you go to the timetable, the actual timetable, page D4, last page of the bundle, actually, you will notice that. Thank you. So you will notice that we start with the opening submissions, 1 hour each, and then we follow with, for day 1, the cross of Mr. Akiki, who is the claimant's factual witness. And on day 2, all of day 2 is devoted to the cross of the 2 respondents' factual witnesses. So factual witnesses first.
Yeah.
And then on day 3 and part of day 4, we have the experts for DCD9. Jimmy Law, the claimant's expert, who gives opinion on both delay and quantum, and and the respondents, 2 experts, because we split delay and quantum, Mr. Lee Spohr on delay, to be followed by Mr. Paul Craig on quantum. So again, we thought that we should group the experts for the TCD9 together, and the remaining of day 4 and the first part of day 5, if necessary, unless we can bring it earlier, are Mr. Millington and Mrs. Levine, which are the experts for TCD3, which are of the same expertise.
Yes, thank you. I hadn't actually noticed that you've done it already. Is that sensible? Yeah, I'm happy with that. Yeah, thank you.
Thank you, my lord.
Thank you, Your Honor.
Now, what next?
I don't know if you have anything else on your list, Your Honor. I have 3 points, two more points on the list.
Mr. Carvelis, I'm not sure whether you can hear me. I talk across you. I'm sorry. All the witnesses will be by video link. Is that right?
Correct.
Yes.
Yep. You talk about administering the oath. Will there be the relevant book in court in some form? The Christian oath is dealt with usually with the Bible available. Is that going to be made available?
Yes, it will be the Holy Quran for Mr. Al-Mahdi, and I think for Mr. Nair also, and presumably, I do not know if Mr. Spohr, Mr. Craig, and Mr. Levine will give an oath or an affirmation. We will have. I assume it's the registrar that we will administer the oath, but we will make sure that they will have the relevant corresponding holy book in front of them.
That's fine. So the registrar will administer the oath rather than the judge. So different systems have different rules about this. In Scotland, we have the judge doing it. In England, it's the court.
Exactly.
I get so mixed. I've seen it happening. I've seen the councils administering.
Yes,
both, actually.
I was going to say I've seen that. I've had to do that once before.
Well, good. That's fine. One point I want to raise with you, but I can deal with it at any time, is the actual sitting time. The hours, because as you know, at the moment, UK is 3 hours behind UAE. So, I think I noticed that the sitting times you proposed were 10 o'clock, started at 10 o'clock UAE time, which is 7 o'clock in the morning. UK time.
If I may, Your Honor, you are absolutely correct. And actually, my first item in the agenda for today's hearing was, is it going to be, and probably a silly question, but I have to ask, it is going to be an online trial, correct? So,
I think so.
Okay, in that case, I think my friend will agree that we're not that cruel, and 7 o'clock in the morning is not the time to start the trial in any time zone.
Good.
We certainly aren't that cruel, are we, Mr. Carvelis?
No, I mean, I wouldn't want to be in your shoes, Your Honor. 7 o'clock in the morning, it's not the time to discuss legal issues and do a trial. I am happy, subject to my friends' availability. Of course, we can start at 9 o'clock UK time. For us, it's the same.
If it's easy for you, I'm quite happy to start at 8 o'clock UK time, which would be 11 Gulf time.
We're in your
want
hands,
to do-
my lord.
I'm good with either, Your Honor. If you prefer 9 o'clock UK time, it's still convenient. It won't make much difference anyway.
Well, let's try and do it 8 o'clock. It means there's you don't waste time beforehand. So 8 o'clock UK time, if it's okay with you. We'll aim to sit from 8 to 9:30. 9:45 to 11:15. Should we say 11:15? And all these are flexible, and we can adjust it if the witness is just about to finish early or something like that.
Yes.
And then in the afternoon, 12:30 to 2 o'clock. The afternoon doesn't divide very easily into blocks of an hour and a half.
Or 12
then,
or for 2:15, perhaps, Your Honor, might be easier.
12:30 to 2:15, and then finish for the further session. Or we could have 12:30 to 1:45, and then 2 till 3.
Yes.
I think your memo suggests we shouldn't have longer than an hour and a half because it's always difficult for witnesses. 12:30 to what? 1:45.
Yes.
Okay.
And then 2 o'clock to 3 o'clock.
Yes. And I assume this will give us the opportunity, if we need a little bit of extra time, we can have it at the end of the day, which is more practical.
We'll assume that we'll stop at 3 o'clock unless there's something just needed finishing off quickly. Happy with that?
Yes.
Right. Can you maybe put those into some sort of agreed revised timetable or something like that, and then send it to the court?
Yes, will do.
And put it in UAE time as well as UK time.
Yes, will do.
It perhaps ought to be more officially done. Right. What else needs to be discussed? Mr. Costello, before I ask Mr. Carvelis, who I think has 1 or 2 points, do you have any further points to raise?
There's only one point which has already been raised with Mr. Carvelis's team, and it's only to do with the experts, in that there was a consent order, which I can take you to. If you just bear with me one moment.
I prefer not to go to it unless you want me to, because there's always a risk when I go get a document without downloading it that I lose you.
Right. Okay, well, I'll see if I can deal with it without having to. I don't think the content of it is not going to be controversial. It's going to be what happened as a result of it. The consent order provided for the quantum and delay experts to have met on or before the 20th of May. Now, I think they in fact met on the 23rd of May, which no one's taking an issue with that. Yeah. But certainly they need to provide their joint report by the 31st of May, which is the Tuesday.
Yeah.
Now, as far as I understand it, Mr. Lowe, who is the claimant's expert, has met with both of the experts for the defendant, but with Mr. Paul Craig, who is the quantum expert, they have not been able to discuss the matter. I think there's the contention between the parties is Mr. Lowe says that Mr. Craig didn't engage, and Mr. Craig says, well, there are certain matters which he can't answer because it's beyond Mr. Lowe's. Mr. Lowe didn't provide any substance within his own report. I don't want to get into the details of it because I don't think that's going to be productive for today's purposes. I'm just giving that as background. The only concern I have is, of course, as things stand, there won't be a joint memorandum dealing with delay and quantum because only the only the delay side of things has been dealt with. The quantum side has not yet been resolved. Now, the parties have been in communication to try and progress matters, but I feel remiss if we don't mention it to the court, because what we don't want is for the court to be unaware if indeed we turn up the trial and there isn't a joint report dealing with quantum. I raise it just so that the court is more aware than anything else at this stage. I'm not sure that the court can really intervene, because I think it's beyond perhaps.
Yeah.
Sorry.
But I wonder, Mr. Costello, if this is the solution. As I understand what you're saying, they have met. Mr. Lowe and Mr. Craig have met. They each have some difficulty with agreeing everything and arriving at a joint report for different reasons. But can they not agree what they can agree and then identify what is not agreed?
I think the problem is that Mr. Lowe says, well, Mr. Craig just wouldn't engage, so therefore he can't even gauge what can be agreed and what can't be agreed. And then, as I understand it, Mr. Craig is saying, although Mr. Carvelis should really clarify this as opposed to me, but I'll make my submission. As I understand it, Mr. Craig says he's not expected to, he can't possibly comment on matters which Mr. Lowe hasn't made any given any opinions on. The reason why I suggest getting into the nitty-gritty of it right now is not really going to be productive, is because it's a he said scenario, and that perhaps isn't going to be of use to the court. What I'm saying is, I think it's right that the court should be aware that there is this friction.
Yeah.
There isn't as it stands, as it currently stands, because as I say, the reason why I say that is because we're hopeful that we can try and get this train moving and to pull into its station, but to try and get the experts to meet again and see what progress can be made. But I flag it in case we do get to trial and there isn't in fact a joint report dealing with the quantum side, and therefore the terms of this consent order wouldn't have been strictly speaking met. But anyway, I raise it. I'm not sure the court can really intervene at this stage, but I think it's right to raise it.
Right. Mr. Carvelis, is there anything you want to add on that aspect?
Yeah, yes, if I may, Your Honor, because a couple of points actually. If I may, I'm not sure that my friend's description is entirely accurate, because it is my understanding that Mr. Craig's response to Mr. Law was not that he could not answer to issues that they were not included in Mr. Law's report. Actually, Mr. Craig's point was that some of the issues that Mr. Law wanted Mr. Craig's opinion were out of scope for an expert, were legal issues, for example, contract interpretation, which Mr. Craig obviously is not the right person to give an opinion. For example, as I understand, as to whether the claim should be made against the main contractor as opposed against the employer, as it is our case. So I think this was Mr. Craig's objection, if you like. Then, and if I'm honest, I was a bit surprised.
Mr. Carvelis, just to give it, using that as an example, surely the experts, if they can agree other things, they can have a note saying we could not agree this because one takes one view, one takes the other, as to whether it's within the expert's competence.
I agree, Your Honor, and actually the next thing I was going to say is that it is news to me that there will be no joint report. I was of the impression, and that's what I heard from our experts, that they will produce a joint report on it. They are still in the process of producing a joint report on the 31st of May, next Tuesday, which will include a column which will say, Mr. Craig, for example, might respond that it is my view that this is out of my scope, so I will not pass an opinion on this. And of course, it is for the judge to decide if Mr. Craig's or any experts at the end of the day opinion is justified or not. I mean, I don't know if my friend has heard differently from his expert, but I'm still of the impression we're getting, and I hope that we're getting a joint report.
Okay, well, that's useful. Mr. Costello, I'm not going to ask you to give your own understanding. You've done that already. But it seems to me if the experts are still trying to meet, that is a good thing. Still trying to produce a joint report, that is a good thing. And if they can identify, if they can't agree with certain matters for reasons such as given by Mr. Carvelis, then if they can identify those matters and we can just deal with that at the hearing as is best.
Yes. May I say this? What Mr. Carvelis says is right in the sense that if, for example, Mr. Craig thinks something is out of scope, or at least that's his opinion, fair enough, he can make that point and he can record it. I don't disagree with that. What I suggest is that the experts really should be meeting and to hash through all of the issues that they need to go through, including issues of quantum. And if, for example, Mr. Lowe raises something which Mr. Craig believes is out of scope, that's the comment he provides, and then we can deal with that at trial. But I think as things stand, not that there won't be a joint report, strictly speaking, there just wouldn't, it seems to me, as far as I understand, that the joint report is not going to be of any benefit because they haven't properly even discussed quantum. What I'm suggesting is that actually the experts should meet again, perhaps this time with a little bit more of an open mind, and to just go through it methodically, what they can agree, what they can't, etc. So essentially, to have another bite at this of this cherry to try and.
I think you're both, if I understand it, both wanting the same thing, and it's a question of whether the experts can be. Can get themselves into the right frame of mind to do it. I'm not going to make any ruling. I don't think I can't. It would, if it needs to go beyond 31st May, so be it. I don't suppose either of you is going to take a point on it if it's a week late. Better it's a week late than doesn't happen at all.
No, fair
enough. For whatever is worth, Your Honor, if I may, of course. I mean, I don't want to cut you off. I think we all agree it would be very useful to have a report. If my colleague wants another meeting of the experts to urge the experts to meet again, I wouldn't have any objection, although I'm not sure I see the point. I mean, they've met, they've exchanged drafts, as I understand, of reports already. I think it's now mostly a matter of sitting behind each one behind their laptop and just typing and finish this exercise anyway.
I think I better leave it to them to decide whether a further meeting would help them. But I'm not going to stand in the way of anything that would encourage them to reach some joint report. So let's leave it at that. But if you can both report back that I am very keen that they should reach whatever agreement is possible.
Yes. Well, that certainly will help. I'm sure it will help. But thank you, my lord. That was the only matter that I needed to raise.
Mr. Carvelis, did you have more points you wanted to raise?
One, and I'm sure it will be quite quick. Presumably, the witness statements will be the examination in chief. You will not require any examination in chief of the factual witnesses, Your Honor.
No, I don't require any further examination in chief, but sometimes in the light of maybe some expert comments, if parties find it useful to bring out a particular point because it is suddenly seen to be relevant, which it wasn't before, then I don't mind 5-10 minutes examination in chief, but it should be indicated to the other party in advance if that's going to happen.
Fair enough, Your Honor, and I assume you wouldn't. And of course, if my friend would like to have 1 or 2 minutes for some warm-up questions, I understand that none of the witnesses, the factual witnesses in this trial, had the pleasure of sitting in the box before.
No. In my practice, before coming to the DIFC court, I always would allow a few minutes warm-up just to make a witness feel comfortable. But it's up to you.
That's very helpful.
Thank you. That's all.
Sorry, my lord, I didn't hear that.
Only a couple of minutes of that, but sometimes it does happen. The case has changed its shape slightly once you see the experts, and if that happens, then if with advance notice to the other side, if you want to develop a point slightly by reference to the witness statement, then feel free to do so.
Yes, just so, of course, for the sake of parity, the only, as it stands, subject to what my lord has quite rightly said in terms of any supplementary substantive questions, in terms of the warm-up, in inverted commas, I would have only gone through some background, history, just personal and perhaps professional, but not just to warm up the witness. But that would have been my intention.
A few minutes. I have no objection to a few minutes of that, but as long as you keep self-restraint is important.
I will have a timer to make sure.
Yes.
Thank you, Your Honor.
Mr. Carvelis, anything else?
No, thank you.
No. As I say, just I should emphasize the point I made about timing. We will be flexible with the precise cut-off points and restarting points, depending on how the evidence is going, whether the witness looks as though he needs a bit of a break at an earlier point or whatever. But generally, we'll try and stick to the hours that we've indicated. And as I say, if you can record those and send them to the registry, that would be helpful, or put them on the e-bundle.
Certainly, the current timetable has said that we will aim to adhere to the schedule, but the court will afford some additional leeway if and when necessary and required. So we will file the amended timetable in light of the timings that we've been through.
That's helpful. Thank you very much. Is there anything else either of you want to add at this stage?
Not for me, thank you.
No, Your Honor. Thank you very much.
Thank you. Well, I look forward to seeing you both on the 27th of June. Thank you.
Thank you, my lord. Thank you.
Bye.
Bye-bye.
Bye.